Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Thank you guys so much for joining us on tonight. Thank you for joining the channel. If you have not done so, make sure that you hit that like button on your way in. Subscribe if you haven't done so already. We have fun over here. We are our self-proclaimed social media jurors. So what we do over here is we go over all of the trending cases from the neighborhood to Hollywood, and we're not doing anything different tonight. So again, make sure that you guys hit that like button, subscribe if you have not done so already. I'm going to speak to a few of you guys, and then we are going to get right into it. Thank you so much again, Daniel, for coming on over here and hanging out with us. Lovely 31 Print Cupcakes, Betty and Linda. Thank you so much. My brother is in the house. You guys keep talking about these t-shirts. They're coming. These t-shirts are coming probably in the next couple of weeks. Jacque, thank you so much. I know I'll probably mess your name up. I'm sorry, sis. I'm sorry. Alice, good to see you. It's good to see Valencia, and it's good to see my girl Love Jones. Good to see you over here again. I know you've been going through some things. We appreciate you over here, and we missed you, sis. Miss HLS, good to see you. All right. You guys know I love you. You know I love you. It's 160 of you already in the chat, ready to get into it. So I'm not going to hold you guys much longer without getting into what we're going to talk about today. So we have been discussing Ronald Lucas. Yes, that is what we are talking about, is DJ Envy and Cesar Pina. For those of you that have not been following this saga that has been going on for months, but we just started covering it on this platform. So Cesar Pina, for those of you that don't know, was arrested, and we went over that last week. And he is the business partner of DJ Envy, who is the DJ over there on the Breakfast Club with Charlamagne the God. And DJ Envy has been very, very interesting lately, because at first, when Tony the Closer, he brought a lot of this to light for us, where people were saying that they were being scammed. There were several allegations, several lawsuits of individuals being scammed by Cesar Pina, who again is the business partner of DJ Envy. So DJ Envy promoted these real estate classes, and Cesar would just sit there looking crazy like, I'm flipping NJ. He would say, I'm DJ Envy, flipping NJ. I'm DJ Envy, flipping NJ. That's all he said. It's all Cesar said. And then here comes DJ Envy, using his charisma and his fame and his notoriety to basically get people to come to these real estate classes. And he claims he was trying to empower the community. But then floods of allegations started coming in with people that were alleging they were being scammed. And we read the criminal indictment, where it sounded like what we would call a Ponzi scheme, where he would have multiple people investing in one property, and the house would be worth $100,000, $200,000, but then he'll have $5 million worth of investments. And then he would promise these ridiculous returns of 30%, 20% within 5 months on top of the money that you invested. So it is alleged that he used the notoriety and the fame of DJ Envy in order to carry out this scheme. Now, a lot of people are, on DJ Envy's head because they're like, dude, it's no way that you did not know what is going on. He had that plausible deniability going on, saying, I didn't have any money in my hand. I didn't take anybody's money. I didn't charge for anything. But the problem is, like Ronald is saying, there are so many clips and videos going around where DJ Envy is not going to be able to separate himself from this. It's just no way that you can separate yourself and just say, I didn't know what he was doing. When you were vouching for him, you were validating him, you were doing all of that because the dude wasn't even really talking. If you look at the videos, he's sitting back in a chair. Sometimes he just stand there flipping in J. He really didn't say anything. So how are you really legitimate? Well, I didn't know. Well, ignorance of the law is no excuse. And I think he's learning that as this process is going on. Because now there's videos, as Ronald brought out, of DJ Envy with videos showing people properties. There's videos where he's picking up rent. It was on Twitter where it was like a video of him picking up rent with a bunch of envelopes. But then there's also videos of certain celebrities that were saying, yeah, it sounds like a scam to me and you going to jail. So I'm pretty sure the feds have looked into emails, DMs, especially if anybody has reached out to Envy and told him, hey, dude, I got like, what's up with your man's taking my money, So I don't know how he's gonna separate themselves, but we're gonna watch it as it unfolds, as we always do. Everyone is innocent until proven guilty, and it's no different in this situation, regardless of how disgusted we all feel right now. But you said, was this man vetted by the radio station or anyone? Well, the man got on the radio station, Sunflowers, and pretty much acknowledged that he had a criminal history. And I mean, Cesar, he had a criminal history of, I believe it was credit card fraud that he had done some time for. And then he said he learned his real estate, his mastering real estate, his guru name from someone that was a developer in prison. And so they flipped this into a giving you another chance type of a deal. And just because you've been convicted doesn't mean you can't change. But that was kind of like the presentation, because there's a lot of people that can relate to him. So it's like if he did all of this stuff, maybe in his younger years, he was able to change his life around, and I can change my life around. And so I think and one of the things Envy was saying was he talked about his integrity and his persona in the media and in the public. Yes. And that's what the issue was. People trusted him because of Envy. I really believe that. There are so many people that said I would not have invested in this flipping NJ fella because he looks just, I don't know. DJ Envy basically vouched for him is what it looks like to me. He vouched for him, in my opinion, and that gained the trust of other people. Well, if DJ Envy trusts this guy, then I'm going to trust this guy. So what was very interesting to me is I've been watching, just so I can keep my ear to the social media streets whenever I get a chance. And Cesar Pina, I don't know what this new generational thing is where folks want to litigate on social media. So Cesar has been posting on social media. And so this morning, if you saw my thumbnail, I noticed a post that Cesar Pina posted this morning, and he said that one of his civil lawsuits were dismissed. And by reading the order itself, I knew that it was misleading. When he said it was dismissed, I knew it was misleading. So we're going to go over because there were several civil complaints that were filed against some of people trying to get their money back. So the first thing we're going to do, the first order of business is now we're going to have to backtrack and go over the complaint that he's referring to. And then we'll go over the process of how we got to that document that he is talking about. And then we can decide if he was being truthful when he put on his Instagram that we are all talking about all of his losses, but we need to talk about his wins. And he put dismissed based on what was said on the record, is what he said happened in that case. So let's go and look at this complaint. So we can see what this specific person was accusing Cesar of. Let me see. And I was looking at it because the actual attorney has an address like down the street from my office. I was like, oh, okay. So he obviously practices in New Jersey, but he is in office here in the great state of Michigan. So this is a case that was brought by Ransom Endeavors Inc. and it's against Warehouse LLC. Remember, we went over that they filed bankruptcy a few months back, and Cesar Pina, and then they have John Doe's 1 through 2 and ABC Corporations 1 through 10. Oh, that's 1 through 10 too, John Doe's. So let's just go over the facts real quick so we know what's being alleged in this complaint. So we know what he's talking about, that he was this winner on. It's so deceptive. It just irritated me because you're really accused of being deceptive, and then you're going to use your social media platform to continue the deception. Is beyond me, but hey. So I'm just going to go to the facts. Let's just hit the facts. So let's go to the facts and facts comment to all accounts. So between December 2019, again, this is just a pleading. Everyone that follows me knows, and it's in the disclaimer, that pleadings are just allegations. Anybody can make allegations. It has not been adjudicated, so there hasn't been a verdict. There hasn't been any for real, on the actual claim. So these are just allegations. Between December 2019 and November 2022, plaintiff attended multiple seminars hosted by defendant Cesar Pina to learn about the business of real estate and potential real estate investment opportunities. Subsequent to attending the seminars in 2022, on or about November 9th of 2022, plaintiff met with defendant Cesar and advised that he had recently settled a personal injury case. Thus, he had approximately $200,000 in liquid assets. After discovering that plaintiff had approximately $200,000 in liquid assets, defendant Cesar Pina was represented that he has a vast experience in the business of purchasing, rehabilitating, and flipping homes, and that there was at least one new project that plaintiff should become involved in. So, oh, you got 200K? Bet I got the property for you. That's pretty much what he said. At the November 2022 meeting, defendant Cesar Pina sold plaintiff on the dream of real estate success by promising plaintiff a 30% return within 5 months if plaintiff loaned him $200,000 to complete the purchase of a new property defendant intended to renovate and flip. So it's almost like he was using, I guess, these individuals as a hard money lender with this 30% high rate, I guess is what it would be comparable to. Defendant Cesar Pina stressed that he works with numerous celebrities. His past projects have all ALL, been extremely successful, and that he was so successful that defendant Cesar Pina was collaborating on a television show for A&E with his partner DJ Envy and celebrity musician 50 Cent. Defendant Cesar Pina represented that if plaintiff provided $200,000 for the purchase of a property located at 89 Franklin Avenue in Hawthorne, New Jersey, defendant would be able to purchase the property, complete the renovations, sell the renovated property, and return to plaintiff its money plus an additional 30% within 5 months. Furthermore, defendant Cesar Pina represented that should defendants fail to pay plaintiff the total sum of the $200,000 plus $60,000 interest within five, that is a crazy return. $60,000 plus your 200 within 5 months, defendant would pay a late fee of 5% to plaintiff. So he said, if I don't got, he guaranteed it where if I don't pay you back this 200,000 plus this $60,000, I'm going to pay you a 5% late fee on top of all of this good money I'm about to give you within 5 months. On or about November 9th, 2022, defendant provided plaintiff with an agreement entitled Joint Venture Agreement memorializing the terms of the proposed deal. And he has that as Exhibit A. On or about November 10th, the parties executed the Franklin Avenue Joint Venture Agreement. Pursuant to the terms of the parties' agreement, plaintiff provided defendants with the requested capital, $200,000, for the purchase of the property. Upon information and belief, defendants never intended to utilize plaintiff's capital for the purchase of the property, as same was previously owned by the defendants. Now, this was the problem that I had because, and I was just on someone else's channel, we were talking about this in New York, and I've done this, if you guys follow me on other cases, looking up properties. You can go on, you can look up the properties online and you can see the chain of the title of ownership. If you were about to invest in a property, I just don't understand how you don't at least look the property up, even if you're not savvy, how you don't look the property up and see like who the owner is and how much they paid for it. Like, how do you even know you're getting a good deal if you're not really looking at the properties to see what the property is worth? But that's just the somebody said Zillow. Jack Queen said all they had to do was look on Zillow. Yes. In New York or New Jersey or North Carolina, you can do the same. It's public records. Yes. So that right there was just like, people really, because a celebrity attaches their name to it, it just shows the power, I guess, of influence, because somebody that was known, whose name was attached to it, and they said they trust this guy, they invest their money in this guy, they look successful. But you're not looking at DJ Envy has all these other streams of income. How do you know that his looking of success is all coming from real estate? It's just the trust that people place in it that still just bothers me a tad bit. It doesn't negate the fact that if he allegedly did this to these people, that, you know, he was wrong. He obviously was wrong if he did this. But, you know, sometimes we got to take some accountability for our actions as well. So anyway, so, upon information and belief, the representations contained in the Franklin Avenue joint venture agreement provided by the defendants were knowingly false and intended to deceive the plaintiff. Upon information and belief, defendants made numerous false and misleading representations to plaintiff with the expectation that it will rely upon same and provide the requested capital. After providing defendants with the agreed upon capital, plaintiff requested additional information, status updates, and details about the project on numerous occasions. Subsequent to receiving plaintiff's capital, defendants ceased responding to plaintiff's inquiries in timely manners and became elusive. Between January 2023 and mid-April 2023, defendants failed to communicate with plaintiff and or respond to plaintiff's communication attempts. So from January through April, Cesar allegedly just stopped talking to this entity or person, because they had it obviously in their company name. Eventually, plaintiff and defendant met, whereby defendant Cesar advised plaintiff that the project was proceeding as planned and that the market was great at the moment and that the property should very soon. I don't know what that was supposed to be. Okay. Furthermore, defendant Cesar Pina advised plaintiff that he should only pull out the interest he is due and roll the principal over into some great new deals he had in the pipeline. So you're gonna ignore me for 3-4 months with my $200,000 and then tell me, well, once I get the money, pull the interest out and give it back and roll it back into some more properties that I have. In response, plaintiff advised defendant Cesar Pina that it needed its entire capital contribution plus interest back as was promised, and stated that in the agreement entered into between the parties. On or about April 20th, 2023, defendant provided plaintiff with payments totaling $30,000, representing 50% of the interest due to the plaintiff, and promised that the remainder of the interest plus principal would be repaid within the next couple of weeks. Between April 20th of 2023 and June 10th of 2023, plaintiff regularly contacted defendant Cesar Pina to inquire about the status of the project and when it should be receiving the funds it was owed. Defendant Cesar usually was unresponsive, but when he did respond, he always advised that the closing was imminent but was delayed for some reason or another. Defendant regularly stated that the closing was scheduled to be completed in a few weeks and plaintiff would receive all the funds owed it immediately thereafter. Upon information and belief, the defendant's statements concerning the Franklin property was knowingly false and intended to deceive the plaintiff. Despite continuing to maintain that property in the process of being sold and closing was imminent, defendants have failed to provide any documentary proof to substantiate same to date. Upon information and belief, the defendant's statements concerning the status of the property was knowingly false when made and intended to deceive the plaintiff. Defendants have failed to repay plaintiff the overdue capital, $30,000 in interest, and the late fee in the amount of $11,500 today. Furthermore, defendants have had ample time to provide plaintiff with accurate information concerning the project and to make the payments that were due on or about April 10th of 2023. Defendants are a company and an individual that hold themselves out as an expert in the real estate acquisition, renovation, and flipping business. As a result, defendants were well aware of what was required in order to complete the proposed project and the time frame for when plaintiff would receive the monies owed. Defendant made numerous representations that the project was proceeding and the sale closing was imminent, despite the fact that no closing has occurred to date, and they have failed to provide any documentation to substantiate the representations. Plaintiff has made numerous demands for the funds due and owing to it. Defendant has failed to pay, same to date. The chain of events that plaintiff experienced in dealing with defendant is not unique to the instant transaction. Upon information and belief, defendant's unlawful, fraudulent, and deceptive trade practices are standard operating procedures to which numerous other unsuspecting consumers and individuals have fallen victim. There's 500 of you in the chat. Make sure you hit that like. Again, subscribe if you have not done so already. We are going to briefly go over just what the alleged claims are, but we're not going to go, read all through them because, yeah, it's long. All right, so count 1, violation of New Jersey Consumer Fraud Act. Okay, that's the first count. Count 2, breach of covenant of good faith and fair dealing against all defendants. Count 3, breach of contract against all defendants. Count 4, fraudulent misrepresentation against all defendants. Count 5, common law fraud. Count 6 is unjust enrichment. Remember, we talked about that. That's an equitable remedy. And their prayer for relief, they want interjudgment on counts 1 through 6 of the complaint in favor of the plaintiff and an amount to be determined at trial, and B, compensatory damages in the amount of $241,500 or such amounts as the court deems just and proper, and statutory penalties and damages in such amounts as the court deems just and proper. And D, on plaintiff's New Jersey consumer fraud claim, treble damages. So under the New Jersey fraud claim, if you prevail according to this, because I haven't looked it up, but I have no reason to believe they're not being accurate, you can get 3 times the amount. So plaintiff has sustained as a result of defendant's conduct in the amount of $724,500. So they're asking for, so the actual amount, the compensatory damages were $241,500, but they're saying it should be times 3 because of the New Jersey consumer fraud claim. And so that's what they were asking. So apparently, after this lawsuit was served, he did not, he being Cesar Pina, representation from this corporation that was sued, did not respond to the actual complaint. So because he was allegedly served, this is what they allege, because they did a subpoena saying that they served the company and they served Cesar Pina. Because of that, they requested what is called a default. So a default was requested because they failed to plead or otherwise anything in this case. So this is a default, and you do it to the clerk of the court. So it's just a simple document. Please enter upon the docket the defaulted defendants, Warehouse LLC and Cesar Pina, in the above entitled action for failure to plead or otherwise defend as provided in the rules of civil practices. So this is literally just a document that once you show by a subpoena that you served them and they have not responded in the requisite amount of days, or sometimes attorneys will reach out to you and say, hey, Pam, can we get an extension for 2-3 weeks or whatever? And you agree. So they don't, they have a longer time, but they have failed to plead or defend this case. So they're saying that you should enter in a default. So the court did enter a default. So once that happens, you still don't just automatically win. You have to do what's called a motion for default judgment. And once you file the motion for default judgment, you also have to serve that on the party as well. So this is the motion for default judgment that was filed by the plaintiff Ransom Endeavors. And they have, please take notice. It was real simple. Notice of motion for entry of default judgment that the undersigned counsel for plaintiff will apply to the court to be heard. That its motion plaintiff shall rely upon its certifications and its affidavits and all of that. Well, at some point, the judge actually, they didn't, I don't think they had a hearing on it. But what the court did do is they granted their motion for a default judgment. So mind you, Pena has not come into this case. The company or the representations have not come into this case, but because they have allegedly failed to plead, even though they were served, and failed to defend it, they ended up with a default. And so on September 13th of 2023, a final judgment of default was entered. So it had defendants, Warehouse LLC and Senior Pena have been duly served with process and a copy of the complaint and the above entitled action, and having been defaulted for failure to answer, appear, or otherwise move as to the complaint, and defendants not being infants or incompetent persons, and plaintiff having filed a certification setting forth a particular statement of the items of the claim, their amounts and dates, a calculation and figures of the amount of interest, the payments or credits, if any, and the net amount due. So they entered a final judgment on September 13th, and they entered it in the amount of $724,500. So the court gave the treble damages, plus reasonable attorney fees and costs in the amount of $241,936.66. So we had that $724,500 plus the $241,936.66. in attorney fees. So this default judgment was entered against Cesar. So apparently at some point, Cesar was like, whoa, whoa, whoa. And he must have talked to his attorney, because you're talking about almost $1 million when you add those two up. So he said, whoa, whoa, whoa. So somehow he found out about this lawsuit. So courts generally would like to decide cases on the merit. So if you can show what is called good cause, you can file a motion to try to set that judgment aside. And so that's what Pina did. He ended up getting a lawyer, or he had his lawyer, to file a motion to set this judgment aside. And he starts out and he does his preliminary statement and says, this is Pina and Warehouse LLC's attorney. This matter arises from the entry of a final judgment by default of approximately $966,000 against a company in bankruptcy and Cesar Pina. So remember, guys, on the previous video, I went over and showed that the company was in bankruptcy. And when you do file bankruptcy, it places a stay on any judgments. So he starts out letting the court know that this Warehouse LLC is in bankruptcy, and this is against Warehouse company in bankruptcy and Cesar Pina. It includes treble damages on patently wrong amounts and a large amount of attorney's fees that cannot possibly be upheld. Because I was looking at the amount like $200 and something thousand. I mean, it would be nice. I wouldn't complain if I got that and all I did was file a complaint and default somebody. Shoot, that's a nice little payday. I just wanted to know what he was charging per hour. How many hours was he alleging that he used? I mean, I guess putting the complaint together, he had to read the agreement. Guess he had to look at the law. But $200 and something in attorney fees, I was looking at that. That was kind of wild. But somebody wanted to bless me with that for that minimal amount of work. I'll take it, as long as it's legal. Now I ain't doing nothing illegal. But that was a lot. So he goes on, and a lot of these pleadings, I like to read them because we often get information that we didn't know before. So he starts out talking about the entry of default should be vacated for good cause. And then it has the court rule number on setting aside the default. It has, for good cause shown, the court may set aside an entry of default, and if a judgment by default has been entered, may likewise set aside in accordance with Rule 450. The required good cause showing is setting aside an entry of default pursuant to this rule is clearly a less stringent standard than imposed. And then they go on to the case law. Okay, we're not going to go over that. They liberally construed. Like I said, courts would prefer to argue on the merits than to just do any type of judgments against people. This is a due process, fair judicial system. Use that word. The undersigned. So this is the information that Cesar's attorney is saying why he believes there's good cause to set this judgment aside. The undersigned sent a letter to the court immediately after it became aware of the default judgment. The entry of the default and the default judgment should be vacated for the reasons set forth therein. The reasons are as follows. 1, Warehouse LLC was in bankruptcy when the default judgment was ordered, and the recent entries of default on the docket. This violates the automatic stay of the bankruptcy court. As such, the judgment against Warehouse LLC was improper and must be vacated immediately. Any attempt to maintain the judgment or to pursue the judgment by the plaintiff would be a violation of the law, and that would result in penalties. The judgment was entered by mistake and inadvertence and is void. So that's the first reason. The second reason is a common reason that we see over here on this channel. If you follow me where folks that get these defaults, they always say they never got it. They were never served. So I wasn't too shocked to see this one, but sounds like it's a little bit more to it than the average. That isn't me. That picture doesn't describe me. They never came to my door. I don't know what they're talking about. They kind of had a little bit more information. So they have the defendants were clearly never served. The two proofs of service simply state posted as per entity to leave, whatever that means. They said the actual proof of service had posted as per entity to leave, and then the attorney's like, whatever that means. I don't know what it means either. It is clear from the face of the proofs of service that no one was served per the rules of court. None of the boxes for personal service were checked, and no people were described. Also, only one attempt was made to serve Warehouse LLC, and only two attempts were made to serve Cesar Pina. The plaintiff argued that they were evading service with no basis in law or fact. In fact, the proofs of service do not check the box clearly marked defendant is evading service. So they're saying that, okay, the plaintiff is saying that they were evading service and that's why they had to serve the way they did, and was like, but you didn't even check that box that he was evading service or any other box that would suggest difficulty in finding the defendants. All they had to do was go up to the Breakfast Club. All they had to do was go up there. They could have went to by DJ NVC where he was at, and they probably would have been able to serve him. Okay. The registered office of Warehouse LLC is a matter of public record, and no service was attempted there. Also, an email exchange exists in which plaintiff's counsel shows that he knew he did not have proper service and was asking me to accept same. He said if I would not, he would move for substituted service by mail, which he never did. The undersigned relied upon this, and in turn, the defendants also relied upon it. Also, the time leading up to the default judgment, my client was okay. Before we get into that part, so I just wanted to explain what I just said. So, oftentimes, if people know that I represent certain people, because a lot of people retain attorneys and that becomes their personal attorney, their go-to. And if they know that and they're about to sue my client, they may call me and say, hey, will you accept service on their behalf? I'll have to call my client and say, do you mind if I accept service on your behalf? Or if, for instance, like on the internet, a lot of lawsuits show up and we'll talk about them and they haven't been served yet. If somebody got an attorney and they retain me, I can call the attorney and say, hey, I'll accept service on my client's behalf. But it's up to the client, obviously. And or you say, listen, just let me know once you serve them. That's usually what I do. Let me know when you serve them. And that's that. So it sounds like the plaintiff's attorney knew who his attorney was, who Cesar's attorney was, because there are several lawsuits out there. So it's probably the same attorney, I would surmise, and asked him would he accept service, and he must have said no. So then he said, what happens is you can do under the rules what's called alternative service. And that's not, so you don't do personal service, which is a process service server that comes and says, hey, look to the left. And then they say, you've been served, or however they serve you. You can ask the judge, like, hey, I've tried all that I could, and I'm going to do a motion for alternate service, which can mean I'm mailing it to you, I'm posting it on your door, your last known address, or I'm putting in the paper in some situations. So that's why you have some people that put it in legal news. There are called alternative methods that you can serve somebody, but you typically have to get the permission of the court. You can't just go and decide I'm going to mail it today. But yeah, just to let you guys know, when people come to serve you and you get it and you like, what's this? I don't want this, and you drop it, you've been served. So don't think just because, or if you in my face and I give it to you and you like, I'm not taking that, I don't want that, you've still been served. So that was just free information for you. Don't think just because you decided you didn't want to pick it up, that just means you're just not going to know what's in that envelope. or whatever. So anyway, so this is a part that was very interesting. So he just got done talking about how this attorney contacted him and said, "Hey, will you accept service?" And he said no. So he said, "Well, I'm going to do a motion for substitution of, substitute and do service by mail." But apparently the plaintiff's attorney never did it, according to this attorney. Said that he never did that. And we were sitting back waiting on him to do that by mail, and it never happened. So then he said, also, the time leading up to the default judgment, my client was receiving death threats and threats of death, RAPE, and kidnapping to his family. And he put in parentheses, these threats continue. He has been displaced from his home due to the same and has obtained criminal warrants against at least 4 people relating to such threats. So he's saying he's had to take out some warrants or restraining orders or something on individuals that have threatened his life and threatened his family's life. He discovered the order for final judgment in this case when it was posted on the web in an attempt to harm his reputation almost immediately after it was entered. The likelihood that anyone was personally served in this case is 0, and my client's mental and physical attention to protecting his family from multiple death threats provides sufficient excusable neglect by an interpretation of law. So he's claiming the reason why he found out about this is because I don't know if it was the plaintiff or maybe some of the other people that are following this case, they posted it on the internet that he lost by default. And so that's what according to this document, that's when he got the attention, or it came to his attention that he had this $900 and something thousand default against him. So he goes on, no one accepted service. Service was never effectuated. The court rules require that service on an individual be made service on the person or a member of the household over the age of 14. Only 14? You guys let 14-year-olds accept service? That's interesting. This obviously never happened, and there was no evasion. There was no motion for substituted service. As to Warehouse LLC, Rule 4.4-4 requires that it be served upon an officer, director, trustee, or managing or general agent, or any person authorized by appointment or law to receive service of process, or on a person at the registered office of the principal place of business. This also never happened. From the face of the proof of service, no person was served on behalf of the corporation. Also, the registered address and business address for Warehouse LLC is not the same address where the complaint was allegedly posted as per entity to leave. The default judgment entry of default must be vacated as a clear matter of law. This firm does not accept service as a result of the misleading and improper applications of the plaintiff. This is not a proper way to hail a party into court. Plaintiff must follow the court rules as service. A substantial deviation from the service of process rules require relief from a default judgment, even if the defendant had actual knowledge of the pendency of the suit by other means. So he has case law. I always say, where's your authority? He put it in bold for the court and he underlined it. Sobel v. Long Island Entertainment, 329 New Jersey Superior, I guess, 285, 293-294. That is the site where he said it doesn't matter that his client knew about it, that he had actual knowledge. If it was in proper service, then the law says that you have to vacate this judgment. So then he goes on to number 3. Even if the service was proper, which it clearly wasn't, excusable neglect and meritorious defenses exist. As stated above, Mr. Pina was not aware of the motion for judgment until after the order was entered. He was not aware of proper service at any time. He has been dealing with protecting his family and has been out of the house. The plaintiff's attorney admitted that service was not proper, requested if I would accept it, and stated that he would make a motion for substituted service. That never occurred. Both my client and I reasonably relied upon this and were not informed of the motion for final judgment. As to meritorious defenses, one needs to look no further than the New Jersey's criminal usury laws. The contract asserted, now we're seeing some of his defenses to these lawsuits. The contract asserted and attached by the plaintiff seeks 30% interest in a 5-month period, plus penalties. NJSA 2C 21.19 states specifically that it is criminally usurious to charge at a rate of over 50% interest per annum. This contract was usurious, and the plaintiff unbelievably is seeking to recover treble damages and attorney fees for loan sharking. So he's calling these people loan sharks. Because you come to me and say you're willing to pay me 30%, but then you're gonna talk about the contract and attack the contract and say that it was usurious and it's against the law, that you charging me 30% and you're basically a hard money lender or giving me a loan for this property. So even though I said I was gonna give it to you, you should have said no, because that's too excessive under the law. The contract was usurious, and the plaintiff unbelievably is seeking to recover damages and attorney fees, and that's, yes, loan sharking. That is not allowed under any circumstance, no matter that plaintiff is attempting to present himself as the victim in this matter. In fact, NJSA 31 1 through 3, forfeiture of all interest, deduction from recovery, provides the roadmap for such situation as follows. In all actions to enforce any note, bill, bond, mortgage, contract, covenant, conveyance, or assurance for the payment or delivery of any money, wares, merchandise, goods, or chattel lent, and on which a higher rate of interest shall be reserved or taken than was or is allowed by the law of the place where the contract was made or is to be performed, the amount or value actually lent without interest or cost of the action may be recovered and no more. So he's saying even though he promised them that money, that 30%, under the law, you can only get the money back because this contract was usurious anyway. If any premium or illegal interest shall have been paid to the lender, the sum or sum so paid shall be deducted from the amount that may be due, as aforesaid, and recover half for the balance only. So he's saying if he gave it 200,000, we already know that he's already given them 30,000 of it back. So he's saying basically he doesn't even owe the whole 200,000 anymore, because the 30,000 he paid towards the interest should have been enough. The court not only awarded damages for usurious interest and uncollectible penalties, but it trebled them and added attorney fees per the Consumer Fraud Act. The Consumer Fraud Act cannot possibly apply to treble illegal usurious interest and fees that violate New Jersey criminal and civil statutes. Even more, though, the plaintiff was not a consumer in this loan transaction. The contract appended to the complaint clearly states that the plaintiff provided money and charged interest, and he put in parentheses usurious. That is a contract for a loan and payment of interest. The consumer in all loan transactions is the borrower. Warehouse LLC is not the lender. Plaintiff. Thus, the Consumer Fraud Act does not apply to the plaintiff's claims. Any damages relating to the plaintiff's consumer fraud claims are simply wrong. Numerous published cases exist with regard to loans. All such cases acknowledge that the borrower is the consumer, not the lender. Conversely, the plaintiff, as the lender, committed consumer fraud against the defendant. So he's saying the plaintiff is the lender. So he actually committed consumer fraud against Pina by contracting for a usurious interest, charging for it, then suing for it, as well as an unenforceable 5% penalty. So basically, this man came with a contract, and then when they tried to sue him on the contract, he said that this whole contract is fraudulent and against the law. And actually, I'm the victim now because I shouldn't owe you what I promised you, because this contract should be invalid. That's a defense for you, man. Consumer fraud applies not only to the formation of a contract, but also to the collection of the same. Courts are consistent in ruling that suing to collect debts that are obviously not collectible in consumer fraud, even if the amounts have been received. So then they have a case in Huffmaster versus Robinson. The appellate division explained the effect of a contract that violates the Consumer Fraud Act. The court held, quote, contracts involving consumer fraud as defined in our act and our administrative code are therefore unenforceable by violators. Thus, per the Consumer Fraud Act, the usurious contract is unenforceable in its entirety by the plaintiff. The only recourse plaintiff could possibly have would be in equity to recover its principal, and the plaintiff admitted that some money was paid back to the plaintiff already. Didn't I tell y'all that $30,000 was going to come up? It has stated only one such count for unjust enrichment. The bigger problem that the plaintiff faces is that in its exuberance to sue for usurious and penalty illegal amounts, the damages that it faces may far outweigh any amounts return of remaining principal owed by the defendant. So they said the way this is going to go, the way I'm going to flip it is y'all going to end up owing me money. Suing for a known illegal debt, even if the amount has not been collected, constitutes ascertainable loss in the amount sought, which is to be triple plus attorney fees. The Supreme Court and Appellate Division, they said they deserve triple damages. The Supreme Court in Cox v. Sears held, moreover, by virtue of the contract with Sears, plaintiff incurred a legal obligation in the form of a debt. The debt was presumptively collectible prior to the lawsuit, and Sears filed a counterclaim demanding payment of the full contract price. Sears also filed a lien on plaintiff's house, thereby encumbering the title. We conclude that an improper debt or lien against a consumer fraud plaintiff may constitute a loss under the Act because the consumer is not obligated to pay any indebtedness arising out of conduct that violates the Act. Jeez, Pete. The appellate division cited and followed Cox and Joy System Inc. v. Fenn Associates. In that case, a commercial tenant sued a commercial landlord for consumer fraud for pursuing improper charges. The landlord counterclaimed in an attempt to collect the charges, just as in this case. The trial court found that the landlord's counterclaim for unpaid charges constituted consumer fraud. Fenn appealed this issue. The appellate division upheld the ruling as to the asserted counterclaim for unpaid charges. The court ruled that the unpaid charges constituted ascertainable loss, and the court trebled the damages. Whoa. Okay. So that's that. So the final reason they feel like this judgment should be set aside is this is a lot. So y'all think he knew all of this before he got into these contracts, that they wouldn't be able to enforce them because under the law it's considered excessive and illegal and against the law? So even if you try to come for me, I never really in theory ever got to give you this 30%. See, this is why, because people kept asking me, I'll get into that. Let me do the conclusion so we can finish this. Based upon the above, wait a minute, number 4, sorry. The final reasons that vacating default and default judgment is appropriate is that no one will be prejudiced and that injustice would occur if the defaults are not vacated. The defendants have made this application promptly upon discovering the judgment on the internet. No evidence or rights have been lost. Furthermore, the judgment is for a very large amount that was entered without a defense, without proper service, and based upon faulty application of the law. The conclusion based upon the above final judgment, entry of default should be vacated. The plaintiff must be required to serve in accordance with the rules of the court. The plaintiff may want to consider if a settlement can be reached or if the lawsuit will ultimately end up with plaintiff owing money to the defendants for the plaintiff's aggressive pursuit of usurious amounts, particularly now that it has been laid bare that pursuit of such interest and penalties is not legal. So this might be why, honestly, so people kept asking, obviously there are allegations of multiple counts, multiple people and multiple properties. But there was only one count of wire fraud. But it seemed like in that criminal complaint, they listed multiple things, and you can get somebody on each count. And people were wondering, why did they do the criminal complaint? And I was talking about this before with another attorney. I believe, and we agreed, that it was because they wanted to hurry up. This was their fastest way to kind of stop all of this from happening. Because if this is true, where you can get up out of a contract and they have case law, because honestly, the contract was so egregious and excessive in the first place, and that's no recourse for these people, then that might be a problem. So I would not be shocked if going before a grand jury takes some time. So I would not be shocked if they go before a grand jury and then they come up with multiple charges, based on a grand jury when they have time. But this criminal complaint, I think, was more so to kind of do something to stop the situation, or stop other people, maybe perhaps stop him from doing whatever he's alleged to be doing. Because I don't believe it's going to stop there. I don't believe that even with envy, I don't necessarily believe him, the whole I purposely am trying to be oblivious to everything that's going on the way it appears. I don't think that's going to work out for him. I believe, like I said before, envy is, if he has not done so already, I'm pretty sure he is going to see. And then his attorney today, I guess, allegedly talked to a reporter, and when he talked to the reporter, he told the reporter, I guess, that he plans on talking. This is DJ Envy's attorney, but when he came out, he said DJ Envy is obviously cooperating because he's a victim too. So that's the statement that I guess he said, is that DJ Envy is obviously cooperating, talking to because he's a victim too. So he wants to get his money back, just like everyone else, to get their money back as well. So like now he's the savior, almost trying to help people to get their money back, is how it's being portrayed. So anyways, the reason why we went over this complaint and we went over that is because Cesar posted on his platform that the case was dismissed. That is not true, that the case was dismissed. What happened was, guys, as we read, his attorney filed a motion to set that judgment aside so he wouldn't be defaulted. That is not uncommon, because again, courts would prefer, because judges don't like to get appealed, okay? Courts prefer to allow any type of claims to be litigated on the merits. That's the preference. So yeah, some people, they're just never going to answer and you get a default. But I mean, most of the time, honestly, that I've seen defaults, the judge does set them aside. So pretty much that's what happened on Friday. I think it was Friday. That's the 20th, where this is what was posted. That apparently there was a hearing, this matter being open to the court by Stephen W. Grigel, Esquire, attorney for defendants, Warehouse LLC, and Cesar Pina, for a motion to vacate the final judgment, entry of default, with all file documents having been reviewed and for good cause shown. So he said he gave good cause for why the default should be set aside. So on October 20th, it was ordered that the order that was dated September 9th, that had that $700 and something thousand plus $200 and something thousand on it, in favor of plaintiff, was vacated in its entirety. So it no longer exists. And also the entry of default was also vacated. So what that means now is, now he has the opportunity. Now this attorney has to properly serve him. And then he has the opportunity to respond, answer, or he may respond trying to dismiss the case, basically saying he put forth what his defenses are going to be. He's going to attack the credibility of the contract. Now, I don't know what it is in New Jersey, But in Michigan, they usually construe whatever it is against the drafter. So if you're the one that drafted this contract and it's all jacked up, that's on you. You're not gonna hold me liable and you drafted it. Now that's the difference. If I drafted it and I made it like that, I'm like, yeah, you sign it. But I think there's plenty of, and I don't know what their law is, but that's just how it is here. But there are plenty of people that would say that they all have similar deals of getting, we give you this money and we're going to get a 30% return or a 20% return, and it's all going to happen in 5 months. So what he was using, and it's interesting because now that I read that, I see DJ Envy was saying you use other people's money. He was like, he teaches you how to use other people's money. I guess when I was thinking a hard money lender, I was really thinking about people like that's what they do, like companies that actually do that. I was not thinking in the mind frame of they were literally using these investors as hard money lenders. That's what they were using them as, or purported to use them as. So when you say you're using other people's money, that's what DJ Envy, basically, that's what you're saying. So DJ Envy, that means all of your deals was using other people's money, and he taught you how to do it, right? And I'm not a real estate guru, so I'm just talking out loud, just based on all of the videos coming out and all the things that we've seen. But so again, the case is still going. To say dismissed is it's not accurate, but you are able to defend your case, and the judge agreed that perhaps it was, that the court wants you to defend your case, and that's not uncommon. But he did this whole Instagram post and basically said people are always talking about all of my losses, but I gotta win, and I got a dismissal, and it's just like, dude, stop. That's not true. Oh, he took it down. Did he come to my live? I promise you it was just on there a few, but I got the screenshot. So I promise you it was just on there. I got the whole screenshot. Sorry. Sorry, buddy. He said, does that say case dismissed? It says case dismissed. That is inaccurate. It is not true. Your case got set aside where now you guys are actually going to have to. Okay. Cesar, you watching my live because he sure took it down off that Instagram. Like, I'm gonna make that girl a liar. I got it on my thumbnail anyway, so whatever, buddy. Whatever. Oh God, you said gotta be Jessica. Listen, gotta be a little more savvy. He put that up this morning. You had it on too long. You say ghetto intellect say he is paranoid. He's watching. I like that. He said ghetto intellect. Sophisticated ghetto. Caesar's watching your live so he can come up with the defense straight. He ain't getting it from me. I'm just reporting. He said play it. Like, I don't know what this lady's talking about. I never put that up and said dismiss. He said when he said that, I took it as just what he said. Jessica said, I'm a real estate agent. I saw this scam soon as DJ Envy introduced it on the Breakfast Club. Well, Jessica, why didn't you warn the people? The people needed help. I just don't understand how this man can own these properties already and nobody looked to see who is the owner. How much is this worth? The ones they were going in together, because it seems like it may have been two different things happening. Some people may have been loaning the money, and perhaps some people thought they were going into deals with him. Because if you look at DJ Envy, he was like, I've had a couple of deals with him. So that would be both of you guys putting up money, right, for a property. So it was like being relayed as if I get 200,000 from you, I'm gonna buy this property and we're gonna fix it up and all of that. Then you find out that there are loans on mortgages on these houses, and they end up in foreclosure. So, anyways, guys, what you the red lipstick hustler said he is ridiculous. Well, all of these, I don't know if you guys have seen, there's a lot of videos. Every video that I know DJ Envy, which is he would just be quiet. He would have been quiet because every video, like I said, Cesar doesn't really talk. He's like, I'm DJ Envy, flipping in J. And then he just stands there like a goofball. Like, that's all he was doing. Listen, we're going to be in Vegas and we want to help you guys how to come up in your community and to create generational wealth. So why don't you meet us right here tomorrow at 2225? And I'm telling you, we're going to give you all the tools that you need to do what we're doing. We are going to do this. And me and my partner are going to do this. You guys want to make sure that you keep your wealth coming and coming. It's all him. He's basically the one that talks. And then he sits there like, and according to the videos, he goes and he gets Uber and DoorDash. That's what they said in the videos. They said he was using allegedly he was using some of the money to get DoorDash and stuff. He was getting a lot of food. That's the allegation. But she said I kind of sound like I'm DJ Envy, flipping in J. All right, y'all. Thank you so much for hanging out with me. You know, we got to get back. You know, we've been on the DJ Envy tip. As I get new information, you guys know I'm gonna bring it to you guys. But you guys enjoy the rest of your night. I hope you guys enjoyed the live. Make sure you hit that thumbs up. Make sure you subscribe if you have not done so already. DJ Envy, I ain't mad at you. I tell people my jail story. So this was my only jail story I had. You guys know I have to go to the prisons to see my client. And one time I had a new client and he was accused of unaliving somebody. This was when I was doing defense work. And they had a fight on the floor. So when they had the fight, I go to see this new client. We're in a cell. They got us locked in a cell. So I'm talking to him, getting my notes, everything down. You know, I'm thinking 15 minutes in and out, you know, make sure I get all the information, talk to the family, all of that stuff, because I don't really have all the discovery yet. All of a sudden, all these buzzers go off. When the buzzers go off, they put the floor on lockdown. And so the depths are walking by me and they're looking me dead in my face. And I'm like, can y'all let me out? Like, y'all see me, right? Hello. I'm done with my visit. Please let me out. And they were like, no, we're on lockdown. We can't let you out. I had to sit in the jail cell with this alleged unaliver. I didn't know him then. I don't think he, I don't believe he did. I think he was innocent. But that day, I ain't know him. You know what I'm saying? So I had to sit there with them, and I'm sitting there like so uncomfortable. It was crazy. And I was just so traumatized. So then from that point on, when I would go to this certain jail, I would let them know I had to go in a conference room and they would have somebody there because of the trauma. So I say all that to say that Envy, people can talk about you, but if you up there, I'm not mad at you. I'm not mad at you because I was only there for a couple of minutes. I had my license and everything, and I knew I was going home. But I still did not like that feeling of being locked up in that jail cell. So with that being said, if you want to go tell, if you want to go snitch and do what you got to do what you got to do. I ain't mad at you. I ain't mad at you. Somebody gonna tell, somebody gonna say something. So why not you? So yeah, you said buy DoorDash stock now. He's on YouTube right now. Caesar is them blaming victims, right? Thank you so much, legit hard money lenders don't spot an unqualified borrower or property investment. Both parties are subject to real estate practice and the law. Got you. You said Envy is going to sing. Listen, All right, y'all. I'm out of here. I hope you guys have a great night. Again, don't forget to subscribe and make sure that you like. And I'll holler at you next time.